We'll go ahead and get started today. Welcome to Corrections Committee. We're past the deadline, so there will be no more requests for bill introductions, and so we'll just move right into our final action. And I'm actually going to flip the script on this. Let's go ahead and do 2214 first, because I do know of a number of amendments on the other ones. It'll take a little bit longer. So that's good with you, Natalie. If you will refresh our memory on House Bill 2214, please.
Sure. Thank you, Mr. Chairman. House Bill 2214 changes the name of the Larned Correctional Mental Health Facility to the Larned State Correctional Facility, and it also removes references to facilities that no longer exist anymore.
Excellent. Any questions, committee? Are there any amendments? Any discussion as it relates to House Bill 2214? Seeing none, do I have a motion as it relates to 2214? Representative Titus.
Thank you, Mr. Chairman. I would move the committee pass out favorably House Bill 2214.
Very good. Have a first by Representative Titus. Do I have a second? Representative Resman caught my eye first. Resman second. Any additional discussion, committee? Well, any discussion at all, committee? All right. Seeing none, all in favor of passing House Bill 2214 favorably, say aye. Aye. Opposed? No? Seeing none, that passes unanimously, and recorded votes are Representative Heiberger, Carmichael, and Martinez. All right, let's go ahead and move on to House Bill 2113 and ask Natalie to give us an overview on that bill.
Thank you, Mr. Chairman. House Bill 2113 prohibits the denial of an expungement due to the petitioner's inability to pay their outstanding costs, fees, fines, or restitution. It also provides that the waiting period for expungement starts at conviction or adjudication, and it authorizes expungement for a juvenile adjudication if the juvenile has not committed a felony offense in the previous 2 years.
Excellent. Thank you very much. All right. Well, I have 3 different amendments to this bill that I would like to discuss, and so we'll go ahead and get started with that. Natalie, you can pick which one you'd like to distribute first.
Mr. Chairman, if you want me to, I can distribute them all at the same time.
That's a great idea. Thank you. Yeah, that'd be great. We'll go ahead and get those distributed and wait for those to hit our email box here momentarily. We get that one sent out. Still putting the email together. Okay. Excellent. All right. So I think we have our technical, just a technical amendment up first. Do we have that in our email boxes? Because I couldn't read that even if I wanted to. Why don't you go ahead and start explaining that one, Natalie, while we're waiting for it to hit our email.
Thank you, Mr. Chairman. So when we were putting in the information that would still be available to certain entities for processing the collection of outstanding costs, fees, fines, and restitution, we copied the language in the municipal statute and put it in the district court statute. And so the reference to the contracting agent there on page 14 to 124119 should be a reference to KSA 2169 for the district court records.
All right, I think we're still waiting on that to hit, and I want to make sure everybody has a chance to put their eye up there. It hit my email finally. And this one is titled HB 2113 Technical. It was the one we're looking at first. The email is really slow, the Wi-Fi, at least for my computer. Okay, here we go. All right, committee, any questions for Natalie as it relates to this amendment? Go ahead, Representative Carmichael.
It's just substituting KSA 20-169 for KSA 20-4110.
It's actually,
119.
the strike makes that hard to see, but right now what it says is KSA 124119. That's the contracting statute for municipalities to contract with agents for collection of these debts, but the district court one should be 2169.
Okay.
All right, any additional questions, committee? All right, then I'm going to go ahead and move my amendment. Do I have a second? Representative Smith? This is, oh, sorry, Adam Smith. No. All right, we have a first and a second. Any additional discussion, committee? All right, seeing none, all in favor say aye. Aye. Opposed, no. All right, the ayes have it, so we have that amendment approved. The next one that I want to discuss, this was some concern that I had with the legislation as we reviewed this. And if you'll recall during our conversation, we talked about when the clock starts. So I'll have Natalie explain the amendment and I'll share a little bit more about my thoughts on that.
Thank you, Mr. Chairman. Let me get it shared here real quick.
Yeah, it's titled Clock Start. It is,
So right now, when a person is wanting to file a petition for expungement, they have to wait a certain amount of time after they've completed the sentence for the crime. So they commit a crime, they either go to prison or they're on probation. If they went to prison, they may have a period of post-release. But after all that is done, then a clock starts. And after a certain amount of time, depending on the offense for which they were convicted, they can petition to have that conviction expunged. What this bill does is change that clock to the date of conviction. So you commit the crime, you get convicted, then your clock starts. Your clock is running while you're serving your sentence, whether you're in prison or on probation. It also continues to run while you're on post-release. And so what this amendment would do would be to revert that back to current law to start the clock at the satisfaction of the person's sentence. It looks like we're adding a bunch of words in here, and when you look at it, what you'll see that I did is that these things that were stricken, I just reinserted, and then I struck the language that was new to the bill. So, but basically it's just reverting to current law with respect to that topic.
Thank you, Natalie. Yeah, if you guys will recall during the conversation, we heard from the conferees, one of my concerns was that, in theory, somebody could still be in prison and qualify for expungement the way that it was written. And so I wanted to revert that piece back. It wasn't an important part from what I gathered from the Juvenile Justice Oversight Committee, the interim committee, and it was kind of slid in at the end and, well, still not really sure exactly how that occurred, but regardless, this is my amendment. Questions, committee? All right, go ahead, Representative Carmichael.
So the Juvenile Justice Committee and/or an interim committee, or is that the same committee? Is it the same committee?
The interim committee on corrections and juvenile justice, joint committee.
And it recommended that we use a different counting model than what your amendment. I'm not I see my colleague, the ranking member, shaking his head. Maybe somebody else can straighten my mind out. Would you mind?
Go ahead, Representative.
My recollection is we didn't really discuss that issue in the committee, but I think the revisor shook her head at me, so.
This is why we have revisors. They're amazing. Go ahead.
Mr. Chairman, I can kind of explain what the committee action was.
Sure.
You guys did hear, a presentation about expungements. A lot of people talked about expungements. You guys talked about generally this bill, which is the result of two bills that are from the Judicial Council, one related to adult expungements and then a separate one with juvenile expungements. So the joint committee action was to reintroduce that that bill, but then as part of that motion, the person who made the motion said, and also, change the clock start. And so that was in the motion, and so now it's in the motion.
Gotcha. And I wasn't there for the last day of committee. I was in DC at another conference, and so I wasn't part of that.
If I might then, so would the chair's amendment return this to the recommendation of the Judicial Council?
Natalie?
Mr. Chairman, yes, it would. The Judicial Council put forth those bills as separate measures, but this would, contain both together as they came from the Judicial Council.
And the Judicial Council, correct me if I'm wrong, did not recommend changing when the clock started.
I don't know if they have weighed in on that one way or the other, but that was not a recommendation from them for this topic, no.
Okay, very good. Additional questions, discussion, committee? All right, seeing none, I move my motion. Do I have a second? Representative Mon is our second. Any further discussion, committee? Seeing none, I'll close my motion. All in favor say aye. Aye. All opposed, no. The ayes have it, and we'll get that amendment added. Recorded, Representative Carmichael, Heiberger, Schlingensiepel, and Martinez are all ayes in the affirmative. All right, my final one on this. This was called, it's titled Collection Info. Do you want to explain this one for a second, Natalie? And then I'll share kind of my thoughts on that one as well.
Yes, Mr. Chairman. So in the municipal and the district court expungement provisions, as an example, if you look on page, let me find the first one here. The bottom of page 5 and top of page 6, now that these expungements could be granted when there's outstanding court costs, fines, restitution, et cetera. It just provides that there's a certain list of people who will have access to the expunged records for the purpose of collecting that outstanding obligations owed. And so what this amendment does is to insert similar language for the juvenile expungement provision because it was not added in that section.
All right. Any questions about that, committee? You most certainly can. Yep, the idea was just ensuring that, for the purpose of collecting the outstanding costs, fines, and fees and restitution, because remember, we're allowing the expungements to occur before those are paid off, but not forgiving that debt per se. There's still a responsibility for certain parts and pieces of that, and this just allows that to continue. Any additional time or questions? All right, then I will close and move my motion. All in favor of this amendment? Oh, did I miss something? I didn't get a second. Could I get a second on my amendment, please? Representative Smith, thank you. Eric Smith, yeah. This is why this takes teamwork, right? And we're all kind of holding each other accountable here. Okay, any additional discussion, committee? All right, now I will close and move my amendment. All in favor say aye. Aye. All opposed, no. All right, the ayes have it. Same recording. Carmichael, Martinez, Heiberger, Schlingensiepel. In the affirmative, that is correct. All right, committee. I am done with the things that I wanted to address on this committee, on this bill, excuse me. Yeah. There you go. We're done. No, just kidding. Additional discussion or additional amendments as it relates to House Bill 2113. Representative Titus.
Thank you, Mr. Chairman. I have an amendment. Pass out the long one. Yeah. The one with all the red. Yeah.
not seeing it? Oh. It appears the state servers are in slow motion.
Moment of personal privilege, sir, while we're waiting here.
Sure, that would be great,
My
Representative.
choreography was off this morning. Can I come over and shake your hand as I was probably supposed to before I crossed the
You're perfectly fine. You did yeah. I was really, really proud of all of our freshmen today. Did a fantastic job in carrying their bills and moving things across the floor. So, yeah, I actually, myself and Representative Eric Smith went on to the left-hand side, expecting you to come to the left when you were done speaking. And lo and behold, we got Representative Sling speaking to move further to the right. I mean, I was thoroughly impressed. So we came and joined you on the right, Representative. It was fantastic. All right, there we go. Now we have the balloon. Moving back over, Representative Titus, would you care to explain your amendment?
Natalie, if you'd like to give a summary, and I'll.
Sure.
Do that. Thank you, Representative Chairman. So essentially what Representative Titus's amendment does is remove all of the changes as it would relate to adults. So both municipal convictions and district court convictions for adults, we would make no change in the law. So we wouldn't be adding that provision about not being able to deny the petition because of the inability to pay. And then as it relates to juveniles, that language would be retained. You can look on page 19. But it would kind of create a different standard for restitution. So it would take restitution out of the provision saying that the court shall not deny the petition for expungement, but then it would add a sentence that says that the court may grant a petition for expungement when the juvenile still owes that outstanding restitution.
So my logic in approaching this bill, I visited with several of my county attorneys and several district court judges. And at root, my concern with this bill is we're ultimately taking away discretion from judges and replacing a statutory mandate in place of judicial discretion in these cases. And I'm just not comfortable going that far with the adults in the municipal and district court. However, based on what I've learned here and what we see in society, I think we are moving that direction with the juveniles. The testimony about how it's more difficult to expunge juvenile cases than adult cases, that was compelling to me. And so I think it's appropriate and it matches the direction of the state juvenile system to move forward with the juveniles, but I'm not quite ready to take that away from the judge's discretion for the adults, at least as I understand it. And then I did make a tweak. I do think restitution is a little different. To dictate to a court to have to not consider restitution, I think is also a bit far, because there can be a wide range of types of restitution owed. So we made it clear that a judge has that discretion if he wants to overlook restitution that's owed when granting an expungement, but I didn't want to sort of take that out of his court. So I'd be happy to stand for any questions on that.
Now, you want to move your motion for me?
I would move my motion.
Very good. Do I have a second on the Titus? Representative Slingensiepin is the second. All right, committee. Representative Heiberger.
Yeah, with all due respect, I'd pretty strongly oppose the motion. I mean, judges still have complete discretion as to whether to grant the expungement based on the traditional factors. And the way I read the bill, if I'm reading something wrong, please tell me. And it also gives the judge discretion to determine whether whether the petitioner is not paying because of an inability to pay or an unwillingness to pay. I think it really guts the purpose of this bill. And I personally believe that just poverty shouldn't be a barrier to expungement.
Representative Adam Smith.
Thank you, Mr. Chairman. I just have a quick question, probably for Natalie. Are any of the amendments that we've previously adopted impacted by this in what's remaining in Representative Titus's bill or amendment?
Mr. Chairman, Representative Smith, so essentially what would happen is the technical amendment would go away, the need for it would go away, because you wouldn't be making any changes to that section anymore. The clock start would essentially have the same effect, because the only part that would remain is the juvenile piece, and we would revert all those changes. For the adults, it would stay current law, and nothing would change. So the collection information, that is in the juvenile section, so those can go on together just fine, and they don't conflict. So, yeah, you'd be just left with the juvenile changes.
Thank you very much, Natalie. Representative Titus, did you have a follow-up for Representative Hyde?
Yeah, it's just, when I read this, I read it as being more restrictive maybe than you do, in that the judge can't use any of these reasons for outstanding fines. The way I read it is they're not allowed, unless you get to that unwillingness or unable to pay decision, a judge can't say owed restitution or owed fines aren't, they have to say, well, I can't consider that as not being in the public interest. And I think that ties the judge's discretion too much.
Representative Heiberger?
I think that's accurate. I think it does remove the judge's discretion to deny the petition based on outstanding costs, et cetera. But, I mean, there's still a very wide range of discretion to deny the expungement on other matters.
Very good. Additional questions or discussion? Representative Carmichael.
You know, I haven't been privileged to serve on the interim or joint committees that we've had that have spent years trying to get us to this point. And the Judicial Council, some true experts, have spent substantial time in trying to craft a meaningful change in what all of us have identified as a problem. And yes, there had to be compromises made, and it comes as no surprise to me that some prosecutors would still like to upset the apple cart. And I'm trying to have I'm having a hard time figuring out what discretion a judge would need that they don't already have under the unwilling or unable to pay provisions of the original bill. So I just hate to see us take all of this effort. We get so close, and then the prosecutors raise their head again and try to torpedo it.
Representative Resman.
Thank you, Mr. Chairman. On an expungement for a felony, you have to wait 5 years before you can start the process.
Natalie?
Mr. Chairman, it depends on the crime, but there are a lot of crimes that are 5 years, yep.
So if restitution hasn't been paid in 5 years, it's probably never going to get paid. In my experience.
Committee, additional questions? Representative Mon.
Yeah, if I might just respond to Representative Russman. Sometimes the restitution is tens of thousands of dollars, and people are making a good effort, and after 5 years, it hasn't yet been completely paid. And so, and this is just talking from my experience as criminal defense lawyer, that there are cases where people are still making payments well after 5 years on a large restitution bill because, you know, they. So it's not necessarily true that just because if it hadn't been paid in 5 years, they're not making any effort. So I take your comment well, but it's not necessarily true.
Yep, Representative Resman.
I've seen that too, and I also have seen where they've gotten an expungement and then they just stop paying. So, you know, and we've always been told that the courts can't guarantee restitution. So,
yeah, fair. Representative Heiberger.
I would just note that this bill doesn't make the cost, fees, fines, restitution go away. I mean, they're put out for collections. They're still subject to collection. So, I mean, I guess it might take some motivation away from some people to keep paying, but the obligation is still there and subject to collection.
Representative Carmichael.
As Representative Heiberger just pointed out, this does not satisfy the obligation to pay the restitution. This is what eliminates the barrier to obtaining employment, which is necessary to pay off the balance of the restitution. That's what we realized was such a self-defeating process, that we're telling people the incentive to pay off your restitution is that you can't get expunged until you pay your restitution. But the problem was you couldn't get a good job unless you got expunged. And that's why we're doing this. Moreover, I just got the contracts literally yesterday and today from the collection lawyers who have arrangements made with 31 of the judicial districts in the state. And I think it's virtually everywhere but Johnson County now. And they're making 25 to 33.33% contingency fee on collecting these amounts. And then that's being added on to the defendant's financial obligations. So they're paying the collection lawyer's fee. But there is every incentive for these collection lawyers to hound these people to the ends of the earth to collect the money. They can't discharge it in bankruptcy because it's almost always an intentional tort. So the bankruptcy court will not discharge an obligation to pay restitution. So were we to adopt this amendment, what we're really doing is making it harder to collect the restitution that is owed to the victims of crime, because the person responsible to pay the restitution won't be getting their expungement, and they won't be getting a job out at the new Apex battery plant in Johnson or Wyandotte County, or the governor's new chip plant in Sedgwick County, the first economic stimulus program the governor's ever done that was a good idea. Thank you.
Yeah, it's just interesting who all the credit goes to. Representative. Okay, additional conversations on this amendment committee. All right, seeing none, Representative Titus, you may close.
Close.
Very good, committee. Having heard the Titus amendment, all in favor say aye. All opposed say no. No. Appears the noes have it. Noes do have it. Those wishing to be recorded as an, hold on, a no is Slingon-Siepen, Heiberger, Martinez, and Carmichael. All right, committee, do we have additional amendments on this bill? Representative Titus.
Second.
Very good. We'll get the second Titus amendment sent out. Okay, should be hitting your box anytime now. Well, while we're waiting, Natalie, you want to go ahead and describe the amendment, if you're good with that, Representative Titus? Very good.
Mr. Chairman, so what this amendment would do would essentially make that change with restitution that we talked about with juveniles for the adult municipal district court and the juvenile expungements. So it would take restitution out of the list of things where the court cannot deny the petition due to the petitioner's inability to pay. And then it would add an affirmative sentence that says the court may grant a petition for expungement when the petitioner owes outstanding restitution.
All right, questions for Natalie? Representative Titus, care to explain?
So the restitution piece was one of the pieces that I think was most troubling when I spoke to stakeholders on this. So this simply removes it from the automatically required category and makes it explicitly clear that a judge, if they want to, can grant an expungement if restitution is owed, but it's not in that automatically requires the expungement category.
Okay, care to move your motion?
I move my motion.
Do I have a second on the Titus? Representative Smith, Adam Smith. Natalie, I have a question for you. Is there really any differing in the effect of law with this? I mean, is it really effectively accomplishing anything different than what the bill already says?
So I'll just say kind of what it does, and then you can determine whether you think that it's different or not. So right now, when someone files a petition for expungement, the court has a list of factors to consider about whether they're going to grant that petition or deny that petition. This adds a provision that says that the court cannot deny the petition due to this petitioner's inability to pay those outstanding costs, fees, fines, restitution. They are able, however, to consider a petitioner's unwillingness rather than an inability to pay. What this new provision would say would just say that the court may grant a petition when the petitioner owes outstanding restitution. And, I'll let Representative Titus explain what he thinks that the difference is there.
It would be the shall on the restitution, changing it to a may. I did, when we had the hearing, I expressed a question about the difference between unable and unwilling, and I think that's a very fuzzy line in many cases, not all cases, but in many cases. And when I talk to folks, that restitution being a little different than the cost, fees, and fines, I would just like to try and preserve some of that discretion, and I think this clearly leaves it in the judicial discretion arena.
Very good. Committee, questions or comments for Representative Titus? Representative Carmichael.
Thank you, Mr. Chair. With respect to my friend, this is how legislative sausage gets made and why appellate courts have to say, what was the legislature thinking? Because this committee has turned down the counterpart amendment offered by the representative. And so now presumably what is offered now is nothing but surplusage. But on the other hand, it could cause a court to start looking and trying to figure out, well, what did they mean? If they said the court can deny on the basis of inability or unwillingness to pay, and then we have another paragraph that authorized the court to grant a petition when restitution is outstanding, what in the world did the legislature mean? Which controls? And I just think that we ought to think real careful. Anytime we upset the apple cart of something that comes through judicial counsel, we probably ought to look real careful at what we're doing. And I think we have the potential with if this isn't surplusage, then maybe it means the court can grant it even in the face of an unwillingness and ability to pay. So I just think it's a bad idea to make law this way. I think we're going to confuse the issue.
Representative Heiberger.
I'm sorry, but I haven't dug all the way through the bill, but because the previous amendment didn't pass, does this mean the new changes are not applied to the juvenile section, or do the changes apply to the juvenile section also?
The changes that were in the previous amendment are not added. The only changes that you have in the juvenile section right now are the clock start changes and then the collection information being available.
So again, I haven't read the whole thing, but this amendment doesn't apply the new pieces added to the juvenile section.
Oh, I see what you're asking. Yes, it does.
It does, okay.
Yes, that is on page 19. So yeah, I would add the exact same provision from Representative Titus's previous amendment. Yep.
All right, committee, additional questions? All right, seeing none. Representative Titus, you may close.
Move my amendment.
Very good, committee. Having heard the second Titus amendment, all in favor of his amendment, say aye. Aye. All opposed, no. No. The ayes appear to have it. The ayes do have it. Those wishing to be recorded, Schlangen-Siepen is a no, Heiberger is a no, Martinez is a no. Is that correct? Very good. And Carmichael is a no. All right, committee, additional amendments or discussion? All right, seeing none, do I have a motion as it relates to House Bill 2113 as amended? Representative Mon.
Mr. Chair, I move that we recommend the bill as amended favorably.
Very good. Do I have a second? Representative Turk seconds. Committee, any further discussion? All right, seeing none. All in favor of passing House Bill 2113 as amended, say aye. Aye. All opposed, no. All right, the ayes have it. The ayes wishing to be recorded, Schlangen-Siepen, Heiberger, Martinez, and Carmichael. All right, committee, that concludes our work for the day, and we'll be back tomorrow. For now, we're adjourned. Thank you.